Hi there, we're here today to talk about the huge settlement agreement that came out with USCIS specifically for H-4, H-4 EAD, L-2, people who've been facing delays with their I-539 applications. My name is Emily Newman. I'm the managing partner of Reddy Neumann PC. We're located in Houston, Texas, and we're one of Houston's largest immigration law firms focusing on employment-based immigration. And today I have with me Steven Brown, who's a partner with Reddy Neumann, and he was the attorney that brought the lawsuit that created the settlement agreement. So this is for now requiring USCIS to go back to when you file your H-1B, your I-129, and you include your H-4 and your H-4 EAD along with it, they have to approve them all together, concurrent approval with concurrent filing. That's how things used to be, and now the settlement requires them to go back to that. So, tell us what kind of brought about this case, this class action. Did it start out as a class action?
No, so this case did. We did file this case at Cooney v. Mayorkas as a putative class action. We filed a motion to certify the class action. So, Emily, you bring up that we're going back to it. So just to provide the listeners a little background, this is how it was until March 2019, USCIS announced that they were going to incorporate a biometrics requirement for I-539s. And then they did that outreach engagement. And they said, we won't be able to do this in premium processing and adjudicate them together concurrently, but that's okay because we're going to prioritize these filings.
Famous last words. Prioritize.
And they didn't. And they were we saw real quick that these were going to take months, if not year, to adjudicate, and they certainly didn't hold there. We plan to prioritize that.
Yeah. So when someone has filed the I-129, filed the I-539, and filed the I-765, we know that the H-1B worker can continue to work while the extension is pending. Is that not true for the H-4s and the L-2s?
No, in most cases it's not. Now, we have some minor circumstances from our earlier lawsuit, the Shergill settlement, where if the H or the H-4 or the L-2 is already extended, that they can have the automatic extension. But generally speaking, there is no automatic extension for H-4 and L-2 spouses. And if you look at the regulation or the notice and comment, especially for the H-4s, their whole reasoning was, what if we have to deny the H-4 or the H-1B? So they don't include that automatic extension for those spouses.
And so what ultimately was happening to people because they couldn't get their EAD cards approved in time?
Yeah, I mean, we were seeing job loss, right? And this whole idea of we're going to prioritize them obviously was not true. And we were seeing delays of a month, 2 months, 3 months. Then it kept growing. It was 6 months, a year. And I think processing times at some of the service centers peaked at a year and a half. Now, that's fine if you can file these early and not have gaps, but you can't file these H-4 EADs or the L-2 more than 6 months in advance. So when you're talking about something that takes 8 to 12 months or longer to adjudicate, and you can't file more than 6 months in advance, there was a mathematical certainty that you're going to lose work. And so it created uncertainty for these spouses and these families and quite frankly, the businesses. We talked to plenty of people that were in hospitals that can I continue to see patients if I lose my work authorization?
In the middle of a pandemic.
Right. I mean, and I know you talk to them, I talk to them. It's like, Steve, I've got patients lined up next week for major issues, but my work authorization expires tomorrow. Am I okay? And the answer was no. And it was these forms, Emily, take less than 30 minutes to adjudicate together based off of what USCIS says, and they're relatively low threshold adjudications.
So what was Reddy and Newman's response to these delays?
Yeah, we saw real quick that these delays are going to be problematic, right? So in June 2019, we were what I believe the first to file lawsuits on these H-4 EAD delays. We saw success in that case. Our plaintiffs got their work authorization approved fairly quickly after filing the litigation. on their behalf, and we built that, and we continue to offer that for our clients and for the community to sue on their behalf, as needed.
So why did we end up filing a class action lawsuit?
Ultimately, a couple of reasons. One, we needed to strike a blow to these two policies. We identified the two policies of the biometrics requirement and the separate processing that were leading to the delays. And we had done a bunch of group cases. The government started playing some games procedurally, and we just needed to end this and get this fixed. And so we brought this class case to try to solve the problem.
So with Edakunni, that's the name of the case, it's been pending March 2021, almost 2 years. What's been going on in that case? What finally led to the settlement?
Yeah, so this case was brought by our firm and then our partners, Jonathan Wasden from Wasden Law and Jesse Bless on behalf of AILA. And we've been fighting this, like you said, for almost 2 years now. And we offered this same settlement, written settlement, in April of 2021 and October of 2021. I found emails where we said this is what we want. But they weren't willing to budge. They suspended the biometrics. We know that. But they continued to face the backlog. In fact, saw processing times get worse to a certain extent. Now they're a little bit better now, but still long. In terms of the case, I mean, we run into the little bit of a issue where plaintiffs were mooting out. They were getting their approval. And so we'd have to kind of backfill into getting more plaintiffs and then letting the litigation process go about. Getting the certified record from the government. The government argues, this is a record review case. So the record contains everything that, they use to make their decision or non-decision. We filed cross motions for summary judgment. Ours was that the record doesn't support it, right? When you look at the administrative record, which is volumes of paperwork, nothing in there shows staffing levels or priorities or anything that would lead to a conclusion that this was a justifiable delay. That was our summary judgment position. And the judge sort of agreed with us and said, maybe they're right. I can't give summary judgment, but I'm open to the idea of discovery. And that's not common in an APA case, to supplement the record through discovery. And we got depositions from USCIS officials as well as data the judge let us try to get, and then right after that was granted, before anything could be produced, the government reached out to us on the settlement.
All right. And so this case is also what caused them to suspend biometrics, right?
Yeah. So that was the first, concession that they made is, hey, we'll suspend the biometrics, and that was up though in March of this year. That suspension, and they hadn't made any formal announcement to continue it, but I suspect it's going to. I mean, they've got to go back now to the concurrent processing. I don't see them bringing back biometrics. And in fact, I think you told me earlier that they had mentioned in one of their outreaches that they were looking to suspend it permanently, right?
Yep. All right, so we have Edakunni. Now, how does the Shergill case work into all of that? Because that's the one that gave L-2 spouses and E visa spouses the ability to work without having to file an EAD. So that was a huge win as well.
Yeah, so Shergill, is a sister case here of Edakunni. When we had filed Edakunni, we were focused on L2, L2 EAD at the time and H-4 EAD. And we had pushed this issue of the L2 incident to status. And so Shergill, we brought that issue again, but we noticed there was also this small gap. There were people who had the H extended or had the H-4 or the L-2 extended, but weren't getting that work authorization. And, like I mentioned earlier, USCIS said, hey, we can't give automatic extensions because what if the underlying status is denied? And so we brought that saying, look, here's a group of people that their status is approved and they're not giving the automatic extension. This, doesn't make sense. And so and then with the L2, the e-spouses, it's statutory, right? They will have work authorization. And so we brought those two, and the government ended up capitulating in that case to give us the L2 and the e-spouse work authorization incident to status. And then the limited, what we were aiming for is a very narrow focus on the people who could get the automatic extension moving forward, who have the status extended.
So with these two cases now, we have L2s and E-spouses can work incident to status, no need to file for the EAD. We have eliminated the biometrics requirement. We got the auto extension for people that qualify for it. Originally it was a 180-day auto extension. Currently it's extended to 540 days until October of this year. And now we're finally going back to concurrent processing of the I-539 and 765 with the I-129.
Yeah, that's kind of where things have led, a lot since 2021, what we've been able to accomplish with it.
All right, so we've gone backwards 2 years.
Right?
Got some wins in between as well, so that's good. So how does this settlement work for people who've already filed? I believe USCIS is saying that if you file now an I-129, I-539, I-765, they'll be adjudicated together. But what about those that are already filed and pending?
Yeah, so they're not subject to the settlement. It's a moving forward, we're changing things. But I do think the processing times are going to get better. When we've deposed or spoken with USCIS officials before that have said this mechanism of concurrent processing makes things more efficient, I think it's going to free up adjudicators that focus on H-4s or focus on L-2s that are filed separately to get those processing times down to be a more reasonable time.
What about premium processing? Do you think everything would be approved together still?
Yes, the terms of the settlement are quite clear. The USCIS is going to go back to the concurrent processing when they're filed together. And I think that's one thing I do want to note. You have to file these together, in the same bundle, the I-129, the I-539, and the I-765 if you're doing an H-4 EAD to get this benefit. If they're separate, a week later, a day later, you won't. But there is no distinguishment in the settlement between premium and regular. So and they used to, right? They used to give that premium benefit to the H-4 and the L-2 spouses. So I think we're going to go back to seeing that because it has to.
All right. Well, congratulations again,
Thank
Stephen,
you.
and to Jonathan Wasden and Jesse Bless on getting this final outcome for us, getting us back to the way things should have been all along. And we're happy to have been able to support that here in Reddy and Newman and to be able to support the immigrant community by getting this benefit for anyone who's in that situation of filing the I-539 and I-765. So thanks for joining us.
Thank you.